Bye-bye. Hello, class. Hello?
Hello, sir.
Hello?
Good afternoon,
Okay.
sir.
Yes, that Farumbi, you are here now. You are not in landlord now. Were you in
Yes,
landlord?
sir. No, I wasn't in London, but I'm back now,
Okay.
sir.
Yes, we talk about equitable interest and we started looking at interest, model, and common law right and those invested by equity. We started by looking at estate contracts, and then we try to look also at the rule of temporary order rule, while prior extempore, also estuary. And we look at competing legal interest, and then we look at the modification. L plus L will give rise to L raised to power 1. E plus E will give rise to E raised to power 1. But there could be instances where this will not be, and that is modification to the rule of priority. Okay, modification to the rule of priority, and we talk about where there's equal equity, and there's also we look at the fact that where there's fraud, negligence, in many cases that priority will be tampered with. Okay, and then when we say it's going to be tampered with, it's talking about it's going to be postponed. Okay, the one that you believe is not going to take priority will be settled before you now talk about the subsequent one. That's the essence of what we have been talking about. And then we look at the case of fire insurance against WIP. I also gave the case of Olifa against Eating, and then Akingbade against Elemosho, and then the case of Oluwa against Oshunusi. And then the second one is what we call restrictive covenant. Okay, and I said to you from Talks and Mose, we all know that the law of contract will say that for you to be able to enforce a contract, you must be a party to that contract. And we said that equitable interest, equity has been able to develop an interest called restrictive covenant, whereby a third party who was never a part of the contract can say, go ahead to enforce that restrictive covenant, especially where it touches or affects the land. Okay, where it touches and affects the land. There is what we call covenants. Okay, in your tenancy agreement, you have covenants. One of them is the fact that where the man puts in a covenant that the tenant shall not sublet or assign, okay, without the consent of the landlord first had and obtained. That is a covenant. Now, between landlord 1 and tenant 1, there's a covenant which shows the fact that you cannot sublet. That's one. Now, in case you sublet without the consent of the landlord to a third party who's tenant 2, the question is whether landlord 1 can now go against tenant 2 when there's no privity of contract or privity of estate. And what we talk about the fact that when it touches on land, it affects the land. The landlord 1 can actually go against the third party. Okay. Another good example has to do with where the usage of a land, usage of a particular piece of land. And I said to you that where a land is restricted, that's where restrictive covenant come in. In Talks and More, you understand the fact that it has to do with garden. where the landowner said, "Oh, I'm assigning this land to you on the condition that you don't touch this land, don't touch this garden." But when the third party he has assigned his interest to the third party who now tamper with the land. But what was the result? The result was the fact that yes, they said because of the fact that it touches the land, it affects the land, then the third party is banned. So these are what we talk about, and this is what we call a receipt covenant developed by equity to make a third party who was never a party to original contract, especially when it affects land or touches on land, to be banned. That's number two. Number three is mortgagor's equity of redemption. Mortgagor's equity of redemption. Now, I said to you, at common law, if a mortgagor fails to repay the amount of loan plus interest by the date specified in the mortgage deed, okay? If a mortgagor fails to repay the amount of loan plus the interest on the date specified by the mortgage deed, he loses every right to recover the mortgage property. Okay, that's common law position. You can no longer recover it. You lost every opportunity to recover that particular property. But equity always regard a mortgage as a mere security for payment of money lent. I'm not selling to you. Once a mortgage is always a mortgage. What we did was the fact that I want to borrow from you, and you have allowed me to also take the loan, subject to the fact that you have right to my property. So equity develop what we call equity of redemption. That is equitable right to redeem. That's what they call equity of redemption. Notwithstanding the fact that the date of redemption has lapsed, equity will still allow what we call reasonable time for you to still pay back the loan, because once a mortgage is always a mortgage. So equity of redemption is quite different from redemption of mortgage. It's not the same thing. Equity is able to talk about redeemability of a mortgage by saying that once a mortgage is a mortgage, I am not selling. I only allow you to take my property. The reason why to today, when you are supposed to pay back loan within 6 months and you fail to do so, equity will not foreclose your right to be able to pay. Equity will still give you a time within which to pay back. And the reason why you have so many rights for mortgagee now, which are really more a long group. You start from a covenant to enforce repayment. You write a letter first. Our loan is due. If you don't pay back, we exercise our right. That's number one letter. Then, if you don't pay, they enter possession. The third one is exercise the right of sale. The fourth one is what we call foreclosure. Okay, but you still have a long way to go before the party will actually foreclose your right over that particular property. But what we are talking about is the fact that equity has developed what we call equity of redemption, allowing you to pay back, notwithstanding the fact that the time within which you pay back has actually lapsed. Okay, that's equity, and we must always appreciate equity for that. Number 4, equitable mortgage. There was nothing like an equitable mortgage under the common law. What are these equitable mortgage? How do you create an equitable mortgage? What is equitable mortgage? There's a legal mortgage and a equitable mortgage. Out of legal interest or legal rights, there's also the second part of which is an equitable. You have equitable lease, you have a legal lease. You have equitable mortgage, you have a legal lease. This is part of what equity has been able to develop. Hitherto, there was nothing like equitable mortgage. There was nothing like equity of redemption. But equity has been able to develop another alternative interest, which will give the party opportunity, or what we call locus, to go to court against the other party. Okay? And then we talk about equitable mortgage. That equity believe that there could also be equitable mortgage. And how do you have equitable mortgage? Number 1 is when you have a mortgage of an equitable interest. You don't give what you don't have. If my right is equitable, I've told you, how do you have equitable interest in land? Every informal sale of land will give rise to an equitable interest. So if my interest is equitable interest, and I want to borrow money from the bank, I can only create equitable mortgage in the favor of the bank. I can't give what I don't have. The moment they agree to take my equitable interest, I have a land purchase agreement from Omonile, duly signed. It's an equitable interest. And I decided to create equitable mortgage. What the equity is saying that I don't need to have a legal document before I can create a mortgage. Even with my equitable interest, I can still borrow money. So when I'm creating if I have an equitable mortgage document, I can as well create what we call an equitable mortgage. Number 2, agreement to create a legal mortgage. Agreement to create a legal mortgage. Now, equity look on that as on which ought to be done. When you have an agreement to create a legal mortgage and you fail to create same, equity will decree what we call specific performance. Let me give you an example. Section 22 of Land Use Act is clear. It talks about alienation by way of assignment and mortgage. Okay? Now, if both of us agree we are creating a legal mortgage, but unfortunately that could not be perfected because that could not be completed. Okay? Equity believe that there's an agreement to create a legal mortgage, and automatically a legal mortgage has been created. I mean, a mortgage has been created. So equity sees that as done, which ought to be done. Just like what happened now, Awuju Gbagbe against Awuju Gbagbe last machine against Chinukwe. It's inchoate. So if I said create a legal mortgage in my favor, and probably in the process of creating it, we have agreed something happened along the line. Equity still believe that in order not to make it null and void, because anything equitable under the common law is not valid. But the moment you have advanced money to me, that's just what happened in Savannah Bank against Ajilo and Adedeji National Bank. You have advanced money to me, but we're about to sign legal mortgage, and we sign. And the bank is asking me to bring a document of my passport for the purpose of perfection, and I refuse. It doesn't mean that we have not created a mortgage. Under the common law, that mortgage will be null and void because we did not perfect it. But the moment I sign an agreement, loan is advanced to me, I've collected money, equity see the fact that a legal mortgage has been created. That's what we normally say. Once a mortgage, always a mortgage. Okay? Number 3, how do you create another equity mortgage? Deposit of title deeds. Deposit of title deeds. This is where it's common in Nigeria, especially though banks, renowned banks and institutions don't accept this anymore. It's only all these microfinance bank and so forth. But actually, in those days before people stop it, most of these banks stop it, you can actually create a mortgage by mere deposit of your title deed. What you do is just to carry your land agreement or even your CFO without signing any legal mortgage. Take it to the bank. They will collect from you. In most cases, they will give you a memorandum for you to sign, which indicate the fact that we are taking this document from you because you are also borrowing money from us. And there's nowhere they will take the agreement to. They only keep it in their custody as an evidence of the fact that money has been advanced to you. So a mere deposit of title deed to the bank without you executing a legal mortgage or deed of mortgage is just an equitable mortgage. Okay? Now, number 5 is what we call equitable charge. Equitable charge is where you appropriate. Where you appropriate, okay, a particular land for the purpose of loan also. Okay, it's enforceable against the whole world. A charge is where you borrow money, but you apportion a particular property. You appropriate a particular property. A legal charge is what the law recognizes under the common law. You must also draft an agreement. But when you just give a particular property asset, this is not even restricted to property, an asset to the bank to appropriate for loan, you have created a charge over that particular property. Number 6, equitable lien. A lien, what is a lien? A lien is an attachment you have over a property that has been sold, or a property where you want to convey, you want to sell, and the man is here to pay you the balance or the purchase price. Okay? A vendor wants to sell a land, that's the man, the owner of the land, that's the seller. The seller wants to sell the land, and the man pay him 80,000 naira out of 100,000 naira. Okay? He has an equitable lien over the unpaid purchase price, which is 20,000 naira. He can hold on to the land, but he cannot sell it to a third party because the equitable interests have been created. So a lien is when you exercise your right over the fact that somebody has not paid you in full of the property they purchased from you. So you can exercise your right of lien on that particular property. Somebody buy a car from you, you can exercise a lien. He has not paid back, and you exercise your lien over the car particulars, or even a second key. That is lien. But these are equitable interests, which are invented by court of chancery, as the case may be. They were invented by court of chancery, and they are deemed to be a recognized interest because of the fact that equity has given credence to them. Okay, so from what we said from beginning, we can see the fact that equitable interest and nature of interest had to do with the fact that there's those that were molded on common law. And I was able to establish to you that one of them is using the contract, estate contract, to give equitable interest to beneficiary in leases. I mean, in trust. Okay. The second one has to do with those that were invented by equitable interest, and we have looked at them starting from mortgage equity or redemption, exclusive covenant, the vendor equitable lien. Then we also look at equitable mortgage, equitable charge, and equitable lien, as the case may be. Now, to conclude this particular lesson 3, we need to look at doctrine of notice, which I will explain to you. Doctrine of notice is talking. There are 3 types of kind of doctrine of notice. Okay, there's actual notice. So we talk about doctrine of notice. Sorry for the interruption. We have doctrine of notices, which I've taught. I think I've taught this one, but for the sake of emphasis, let me just repeat them again. There's actual notice, which I've explained to you, is direct information or knowledge of existence of an equitable interest received by a third party who, in spite of that notice, still decided to acquire his own interest. Okay, whether legal interest or an equitable interest. The first one to be created will take priority. Direct notice, direct information, direct knowledge. It's common in practice. I've said that to you, where people will be, a land will have been sold, and people are still coming to say, return the money. Anywhere you go, when you grow up and you become a lawyer, anywhere you go and they say, we are no longer interested in selling this land, something has happened. Is that because they've seen another buyer who's willing to pay more, than the first one they paid? So is that they want to pay more? That's number one. Or probably because they have collected money from another person. So it's normal. And that other person that they collected money from knew about the fact that an interest has been created. So it's an actual notice. And we said this is kind of notice that an order of a legal interest in property would be deemed to have been received, and it's not going to be a bona fide purchaser of value without notice of the earlier interest. And you need to notice that. Number 2, constructive notice. And I said that the principle here would have been, we'll talk about the fact that the purchaser will have discovered the existence of an equitable interest or any encumbrances if he had used ordinary diligence and care in investigating the property and the title. So the fact that you did not conduct a search, or you just decided not to conduct a search, if you are done, you will have discovered, you are deemed to have also have notice of that equitable interest. Common one among this one is a legal interest. For every legal interest created in property is registered against that particular land, and it constitutes notice to the whole world. It constitutes notice to the whole world. I said that to you. Every interest you created as legal interest, the whole world is aware. That's the truth. The whole world is aware of the fact that an interest has been created. So, and as such, if an interest has been created, if you choose not to conduct a search, you're on your own. Somebody has given you a number of a CFO, which you ought to have gone, probably inspect. I said to you in this class, I said, for every legal interest created, is like a registration. Okay? Mr. Ade bought a land in 1920, and he had the registered conveyance. In that document, you see the fact that Mr. Ade owned this land. And when you search, you are going to see Mr. A interest on that land. Okay? You are going to see on that land. Now, the moment you don't search for every interest created in a property that's registered, is that land registry. Bank that want to give loan, they don't give loan on the promise or the fact that they know somebody as their customer. They will send it to a lawyer to go and investigate and do a search for them. So if you ought to have conducted a search and you choose not to conduct a search, and at the end of the day, it was discovered that the land is not free, and you still went ahead to buy it, and you are complaining afterward, you'll be deemed to have received constructive notice. The third one is what we call imputed notice. If a purchaser employs an agent and held that agent as his own agent, you know the law of agency, okay? Whether the agent is your solicitor, estate agent, okay? Any actual or constructive notice received by that agent or solicitor, that's what we're saying, would be deemed to have been received by you, okay? You that you are the one that sent them. So if they receive notice about the fact that the land is not free, or they receive anything about the fact that an equitable interest has been created, and they probably did not tell you or they deceive you into believing the fact that the land is free, the question still remains the fact that you have that notice that they receive as your agent is imputed on you. That is what we call imputed notice. And that is the end of lesson 3. And we are left with the last topic I'm going to teach you. And before I started that, I will start that one. Let me ask you any question on what we have done so far on this lesson 3 before I move to lesson 4. Okay?
Yes, I have a
Yes,
question.
sir. Good afternoon, sir.
Yeah, good afternoon.
Oh,
Okay,
you
can
can
we?
go now. Ask after you.
Okay, thank you. Good afternoon, sir.
Yes, I'll
In the
listen to
case
you.
of constructive, yes, in the case of constructive notice, it is only legal interest that we can talk about. We can't talk about equitable interest
Yeah, because
under constructive notice.
yes, there could not be. There may not be way you will be able to discover. For example, if a land is subject to equitable interest and is free, and you ask around you, and then actually it's actually applicable to legal interest, because that's when you could have discovered any encumbrances. You may not talk about it in legal interest, but yeah, equitable interest. But the only way you can talk about it is where you make inquiry. Okay? Or you see where a particular piece of land, somebody put there, keep up military zone, carpet temptor, let the buyer be aware. And then somebody said to you, don't mind them, I don't know who put it there. And you never bother to do investigation. That could also be the constructive notice. But in actual sense of law, is legal interest. Okay? I think that question has been answered.
Okay, sir. Thank you.
Okay. Okay. Any other one?
Yes, I have a question.
Yes, go on.
So just to confirm, you mentioned that if you have an equitable interest, you can only give out an equitable interest essentially.
Mm-hmm.
Okay. That's just what I wanted to confirm.
I'm listening to you.
That was what I wanted to confirm, because I was thinking of
Yes.
a scenario. Okay, makes sense. Thank you.
You can actually convert that equitable interest to legal interest. For example, if Omonile sell land to you, you can go ahead to perfect it and convert it to a legal interest. No doubt about that. But to create a mortgage, if I'm an holder of equitable interest, that's in the nature of my interest, and I want to borrow money from you, I only pass to you an equitable mortgage also. That's what we're saying. I think that's clear.
Yes, sir, but does that mean that you mentioned that big banks don't collect mere equitable interest from?
I'm telling you now, there's different method of creating an equitable mortgage. I've mentioned that to you.
Yes.
How much do you need? Which 500? I'm listening to you.
So does that mean that if I only have equitable interest, that a big bank is not going to give me money?
No. They may create an equitable mortgage for you in another instances. I mentioned 3 types of how you can create equitable mortgage. And I said to you that you can create equitable mortgage by mere deposit of title deed. Are you aware of that?
Yes, sir.
You can go to them and just give them your CFO or even your document that's legal, and they collect it from you and you sign a memorandum. But I'm talking about the fact that if you look at 100% of loan, because that will still be an unsecured loan. What happens in case you now created another legal mortgage after you have created an equitable mortgage? So they are always very, scared and wary of the fact that they would rather want you to create a legal mortgage as against an equity mortgage. That's what I'm trying to let you know. I don't know whether you understand. They are reluctant, not that they don't create it. If they know you very well and they want to help you, they must still create a legal interest, equitable interest. And in creating a legal equitable interest, they will collect your original certificate of CFO. But what I'm talking about is that people have a way of creating a legal interest after a mere deposit of title deed have been done to a particular bank. Because you can go back to the same registry and collect what we call CTC, certified true copy of the same document, and swear to an affidavit that you lost your original document, and you still go and create a legal interest for another bank. So that is why banks are really weary, or they stop granting an equitable, in mortgage. I'm not saying they are not granting it again. They just reduce it. That's what I'm saying. Did you understand?
Yes, sir.
Okay. Another one?
Yes,
Another
sir.
question? Yes.
Well, I have questions. My first question is, you mentioned that we can convert an equitable interest
Can you speak up? I can hear
to a
you.
legal interest. Right. So on that background, I wanted to ask, can you hear me now, sir?
Yes.
Hello? Okay,
I can hear you now.
You mentioned that we can. Okay, thank you. You mentioned that we can convert equitable interest to legal interest. So flowing from that, I wanted to ask, what exactly does it take to create a legal interest beyond just having the C of O?
C of O is not only a legal interest. I mentioned it to you. I mentioned that to you severally, that C of O is not only a legal interest. And say for any interest you created, you are perfected. I even went to the extent of telling you that every formal sale of land, every formal transaction you did by reducing to writing, and you register it with the land registry, is a legal interest. It is not necessary that has to be sale. A legal mortgage. A legal mortgage is when you sign a legal mortgage agreement, and then after signing, what happened thereafter? You went back to land registry. Are you still talking? You are listening to me?
I'm listening to you, sir.
You went to a bank to create, you want to take a loan from the bank, and they drafted a legal mortgage agreement for you. How does it become a legal mortgage? It doesn't become a legal mortgage immediately. What are you supposed to do? You comply with Section 22, which requires you to obtain governor consent, and you take it to land registry for perfection. That has converted it to a legal mortgage.
Yeah,
you there? That's exactly what we're saying. Okay. Another question?
My second question. In your notes, please, there's a part that I didn't quite understand. When under modification of the rule of
after what?
Under modification of the rule of
after what? After what? I can't hear you. Your line is breaking. Your line is breaking. I cannot hear you. Hello?
Hello, sir. Can you hear me now?
Yes, I can hear you.
Okay, I said in your notes, the notes you gave us, there's a part there that I did not quite understand. That
okay, where is that?
Light on, and that's under modification of the
modification of what? Honestly, I cannot hear you. It's either your line is not working, or you are somewhere that your line is breaking, or you didn't speak out. Yes, modification of rule of prior extempore. Is that what you are saying?
Yes, sir.
And what happened to it? I've explained the thing to you now. My note is what I wrote how many years ago. I don't even look at the note, only when I want to start cases. So what is the issue? Do you understand the explanation I gave you? Under modification, which one you don't understand? I can't hear you. Maybe somebody else. I cannot hear you. Your line is breaking. I can't hear you. You speak out. Hello? I cannot hear you.
Sir, can you hear?
Why is your volume so low like this? Can you increase your volume? Honestly, I cannot hear you. Are you this way? I cannot hear you. That's the truth. Yes, another person should have another question. If you have, I can hear her. That's the truth.
Good afternoon, sir.
Yeah, good afternoon.
Sir, please, can you go over the equity charge? I didn't understand it, sir.
I say charge is when a property is being appropriated as a security for a loan. You charge that particular property. It's not like creating a mortgage. You are appropriating, you are giving a particular property as a collateral. That's what they call a charge. A charge can be created on any asset, not necessarily property. Okay? You can create a charge. There's what we call floating charge. You can create a charge over an asset other than property. So what you are saying is that you appropriate this particular property, take it for now, while I pay back your loan. That's what they call a charge. It's an appropriation of property for the purpose of discharging an obligation under a loan. So it's not like a mortgage whereby you sign an agreement, whereby you create deposit a title deed, but you just appropriate that particular property as a charge. Okay, that's what we are saying. So that's what they call a charge. Appropriation of property, attaching a property to a particular loan. That's what we are saying. I don't know whether you understand now. Let me get a good example is your car. You can give your car. If you go to, there's a floating debenture, floating chairs. If you go to banks, you see cars being parked. It's a charge. Okay? You can appropriate it for a charge. That's what we're saying. Did you understand now?
Yes, sir. Thank you, sir.
Yes. Another question? Another question?
Good afternoon, sir. Can you hear me, sir?
I can hear you.
Okay, sir. So pursuant to what she said, can you say in differentiating a charge from a mortgage, can you say, okay, in a mortgage, there's an outright agreement that we are going to loan you this money and you use your house as collateral. But let's say in an instance of a charge, let's say you borrowed the money already, but you are unable to pay back. You now say, okay, hold my car or pending the time I will pay back. Can that be like a difference between a mortgage? Did you get my question, sir? Or is it my network? I think it's my network. Hello, sir.
We can hear you.
We can hear you.
Can you hear me? Can you hear me? I can hear you.
Can hear
The
you
network
now.
Go on, yes. Ask your question.
Sir, I can hear you. Can you hear me, sir?
Yes.
Okay, so my
I can hear your
question
question. Can you repeat your question again? Can you repeat your question again?
I want to repeat it. Can you hear me clearly now,
Yes, I
sir?
can hear you, yes.
Okay, so my question is, in differentiating a mortgage from a charge, can we say in a mortgage there's an outright agreement that I would give you my house and you will loan me money? But then in a charge, let's say I borrowed money from you already, but then I'm unable to pay. So I say, okay, just hold on to my car pending the time I pay. Can that be a difference between a mortgage and a charge?
That's one. You see, if you want me to go into a charge now, I will confuse you. That's the truth. It's more bigger than what you are saying. A charge is an appropriation. This for now, because you are going to do a mortgage in second semester, and you are going to do different between mortgages and charge and several other things. At this moment, I just want you to know that a mortgage passes a proprietary interest. Okay, the moment you created a mortgage, it passes a proprietary interest, meaning the fact that the title might still be with you, but somebody else is holding the title in original sense. Okay, but you don't create a proprietary interest as such in charge. You only appropriate a particular property to instantiate on that particular loan. Okay, so you may not even give physical possession, but in most cases, it's common with having a kind of charge. So when you say you appropriate a property as a loan, that is what they call a charge. Do you understand? So it's not like a loan, it's not like a mortgage. A mortgage could be a formal agreement. You can also have a legal charge. There could be a legal charge. There could also be an equitable charge. It depends on the way you do it. But the only thing is that you can only specify a particular property for purpose of appropriation, which is a charge. Okay, every other property can be suitable for mortgage, but in charge is an equitable interest, which where you just appropriate a particular portion for the purpose of that particular loan. And a good example, a charge, it looks similar as if you are talking about a pledge, but it's not. But you just appropriate that particular property and say, okay, take this particular, it can be a house anyway, it can be a machine that you are working on, that you want to buy with that particular loan that's been given to you. I don't know whether you get what I'm saying. I want to buy a machine, and then I can create a charge over that machine, which is the loan you are giving to me. So that loan is being appropriated for the loan you are giving to me. I don't know whether you understand what I'm saying. Did you understand now?
Yes, I do.
You give me money to buy a car. You have a charge over that car now because a loan. You have a charge over that particular car. So that's what we're saying, is being appropriated for that. I mean, I want to buy a machine, and then you can have what we call an appropriation, a charge over that particular machine. When I don't pay back, you can exercise your right over it, but you also have what we call a legal charge. So it's not about documentation alone, because you have a legal charge, you also have an equitable charge. All I want you to know is the fact that you also have an equitable charge, which is an appropriation of property for purpose of loan. At this level, that's what I want to do. If we want to talk about mortgages and we want to talk about charge, we need to look at the three cases. There are remedies, there are procedures for creating a charge, and I'm not interested at this stage, please. Just understand what is a charge. A charge where a particular property is being appropriated for the purpose of a loan or for the purpose of creating an interest in property. Okay? Another question, please. When you do mortgages in second semester, you'll be taught better. But we're going to look at mortgages against pledge, against charge, against several other similar interests. Okay? Any other question, please?
Yes, sir.
Yeah.
Yeah, good afternoon, sir.
Yeah, good afternoon.
Yes, sir. I'm speaking on behalf of Aisha Disu. She said her network was bad.
Yes, what was he saying? Yes.
So she sent a question to me to read out. So she's just trying to seek clarification on where the mortgagee of the legal estate has constituted the mortgagor, is agent to the authority to raise money on the security of the mortgage, and the estate thus created as by the fraud or misconduct of the agent be represented as being the first estate. So she said that she just needs you to explain it, sir.
You are just reading out certain things. So what you are reading, I'll read it again. I can hear you.
Okay, sir. She is seeking clarification on where the mortgagee of the legal estate has constituted the mortgagor, then is agent with authority to raise money or the security of the mortgage, and the estate that has been created by the fraud or misconduct of the agent is now being represented as being the first estate. That's what she said. She needs clarification on that, sir.
He's reading a case out. Which case does he read out? He's reading out a case. He's trying to read out a particular case that I gave to them in the case. We are talking about modification. Who's an agent? An agent is somebody that you heard out to be your representative. Am I right? If you have somebody to represent you, and that person is representing you, an act of fraud, it created a subsequent interest, whether you are going to be banned or not. Because I don't understand that question, honestly. I know that thing was read out from a particular case. He's reading out from a particular case. So I don't get this question. What is the question? Because I heard him talking about modification of interest. You should ask that question in relation to that, not for reading a dictum or a case out. What is his confusion about mortgages when it comes to modification of priority? That's what I want you to ask him to. Ask her to tell me. Because he's reading out.
Can you hear me, sir?
That's a dictum from a case. Yes.
Okay, thank God. So the thing is, I saw it in the notes that you sent to us on that modification of the rule. So I didn't understand it. That was why I asked.
I don't know. I can't remember because I don't even know what I put there. But what I'm talking about
I think you were explaining situations in which the rule that where the rule of quick prior extempore. You had stated the first one, and then you were giving the second modification, the second situation where there will be a modification. But I didn't understand it. That was why I asked.
Which one is the second one that we stated?
So you said secondly, you said first, the court will postpone prior legal interest to a subsequent equitable interest where the owner of the estate has assisted in or connived in fraud, etc., etc. You now said secondly, where the mortgagee of the legal estate has constituted the mortgagor, is agent with authority to raise money or the security of the mortgage.
That one, I think I just saw the note now. That one is not constituted. It's connived.
Yeah?
It's not constituted. Conniving. If you read it, you now understand. Do you understand now?
Where the mortgage of the legal estate has connived with the mortgagor. Is that what you are saying, sir?
Yes. That's what will lead you to fraud now. It's not. So that's an error there. Okay,
right,
you can if you read it now, it will have meaning to you. Yes, any other question?
Okay, thank you, sir.
Okay. Yeah, somebody else is raising up his hand.
Good afternoon, sir.
Yes, good afternoon.
Okay, so my question is on the modification of the rule under fraud or negligence. So in the fire insurance company against WIP, the court mentioned something that mere carelessness or want of prudence on the part of the legal owner will not constitute sufficient ground on the legal estate. So my question is, at what point can we say that is there a dividing line between mere carelessness and negligence? At what point can we divide them, sir?
Can you go over that question again? Can you repeat your question again, please?
Okay, sir. I was saying that in the fire insurance company against WIP, the court stated some cases where the legal interest of a person will be postponed. But then it also stated that mere carelessness or want of prudence on the part of the owner of the legal estate will not constitute sufficient to postpone the legal estate. So my question is, at what point can we say, oh, this person was not being negligent, he was just being careless? What can we say is the dividing line between mere careless?
If you read the two cases, there was one that somebody carelessly left his document in a shape that everybody can have access to. Do you understand? That could be negligence. Connivance is fraud. Where you connive to create multiple interests is fraud. So it depends on the facts of a particular case. You cannot really talk about the fact that it's a sausage. Okay? So if like two of the three cases, you can see there that somebody that probably left a document and another person has access to it and decided to create another interest with it. That's another one. Another one could be the fact that there's a connivance where fraud was actually committed in order to ensure that an illegal estate is postponed. So you can't really have a foreclosed answer like you have brought out. It depends on the facts of each case and what was the merits of that particular case. So it depends on what the man has done to constitute a fraud. It's just like what you have in criminal law. What is fraud? What is negligence? In tort. These are instances we are talking about. So you can't really not, I can't tell you by foreclosing the fact that this is what will constitute fraud and this is what will constitute negligence. It depends on each matter. Somebody that wants to postpone an interest and want to modify based on the fact that I want priority other than you is going to establish the fact that the legal estate was created by fraud or was created by negligence. You that you allege, the onus on you to now establish the fact that you are fraudulent in the nature or probably there's an error on your part. So these are things you need to understand. So you cannot really say these are facts. All facts must be the same. No. It depends on the fact of each case. Okay? That's what I can say for now. Any other question?
Thank you, sir.
Any other question? Thank you. Any other question? Okay, maybe we should stop here so that I won't go through the third because this other topic I'll start on Friday. The last topic from my end is assignment of choices in action. Assignment of choices in action. So I will commence that on on Friday. Leave me alone with your friend. I'll call you later. Okay, I'll comment that on Friday. Somebody else want to talk?
Yes, sir. Sorry,
Hello?
sir. A quick question. Please, what are the three ways to create an equitable mortgage? I think I only understood the deposit of title deed.
Okay, what is number one?
I didn't get that, sir. An agreement to create an equitable interest.
What is number one of all the three means of creating equitable mortgage? Number one is nature of equitable interest. If you have equitable interest, what can you pass? I say you don't give what you don't have. I have an equitable interest. Okay? Number one is mortgage of an equitable interest. If you have an equitable interest, by now you should know what is an equitable interest. Do you know what's an equitable interest now?
Yes, sir.
Okay, what's an equitable interest? Answer, what's an equitable interest?
An equitable interest is one which is protected by equity. That is, it's not a legal interest. There's no legal title or deed protected in relation to an equitable interest.
Every informal sale or every informal creation of any transaction in land is an equitable interest. Formal transaction or formal will give us a legal interest. I said to you when I started Ekunbabi against Abu about you. So if I have an equitable interest and you want to borrow money from me, what kind of interest can we create?
An equitable interest, because you cannot give what you don't have.
That's number one now. As a mortgage of an equitable interest. That's number one.
Sir.
Number two is creation of agreement to create a legal mortgage. We actually agreed to create a legal mortgage, a document that has been signed, which has an intention to create a legal mortgage. And then both of us failed to obtain governor consent. Agreement to create a legal mortgage that we failed to create. What would that happen? Equity look at that as done, which ought to be done. Ordinarily, that should be null and void because we don't obtain governor consent. But we said no. The law now is that it's going to be voidable. So what do we create? What have we created? Thank you. Now the third one, good. The third one is deposit of title, which you say is clear. Is that okay?
Yes, sir. Thank you very much, sir.
Any other question? Okay, we'll stop here. We'll continue on Friday. I will start the last topic, assignment of choices in action. And I want you to read ahead of class. Okay, any other question I did not answer, or probably because I did not answer because this is my third class today. I still have the fourth one. So you can ask me on Friday or some other day. Thank you so much. Have a wonderful evening. Bye-bye.
Thank you so much, sir.
Bye, sir.
Bye,
sir.
Thank you, sir. Thank you, sir.
Bye-bye.
Thank you, sir.